right, good morning. This is Tim Lynch of the Cato Institute. Tim, you are the director of Cato's Project on Criminal Justice, if I understand correctly. Is that right?
That's right. Good morning.
Good morning. And Tim Lynch has a number of areas of interest, but particularly for our purposes, we really root him on in his research in overcriminalization and the drug war. And today, he's going to discuss with us a case that is soon to be heard before the Supreme Court of the United States, and that is the case of Lee versus the United States. Tim, can you give us a little synopsis of what the case is about?
Sure, I'd be happy to. Mr. Lee came to the United States with his family, with his parents in 1982 from South Korea. They came to the United States. He went to high school in New York City. Then he moved to Memphis, where he became involved in the restaurant business. Years later, the government accused him of being a small-time drug dealer. He was arrested for possession of ecstasy. And one of Mr. Lee's concerns when he was brought up on these charges was whether he would be subject to deportation if he were to accept the prosecutor's plea offer. And his attorney assured him that he would not be subject to deportation. So on that basis, Lee took the government's plea offer and pled guilty to the crime. Now, as it turns out, he received bad legal advice because everybody agrees that the attorney was wrong and Mr. Lee is now subject to deportation. So he filed an appeal saying he wants a new trial because he relied on his attorney's bad advice. So he wants to have a new trial. Now, the appellate courts hear these types of claims on a regular basis. They hear people who regret that they pled guilty. So what the appellate courts are wrestling with is on what basis should they grant new trials? And in Mr. Lee's case, again, everybody agrees he got bad, incorrect legal advice, but the appellate court said, well, look, the evidence against him was strong. There was a government witness that was prepared to say, I bought drugs from Lee. We found drugs in his apartment. So the appellate court took the position that the evidence against Lee was strong, so why should we give him a new trial? He's probably going to be found guilty anyway, and then he'll be subject to deportation anyway. So why should we do that? So they're prepared to deny him the new trial. And so his legal team has now appealed to the Supreme Court saying, look, Lee got incorrect legal advice. Everybody agrees with that. But his right to a jury trial is very important. And regardless of whether appellate judges or anybody else thinks that he didn't have a chance to win, his right to a jury trial is important. It's up to him to decide whether to go to trial and accept the risks there, or whether to plead guilty. And that's what the Supreme Court's going to be wrestling with, and why we filed an amicus brief and have become interested in this case because of our work and our common interest with FIJA on the importance of jury nullification and how that's tied in with your right to a jury trial.
And I know that a lot of people don't know what an amicus brief is. Can you just give a general explanation of what that is?
Sure. Now, when two parties, like a prosecutor and a defendant, file an appeal, their attorneys, and there's two sides to a case, and so the government will file its brief, and the attorneys representing Mr. Lee will file their brief. Amicus briefs are when another group comes along and thinks that they can offer the court some additional guidance on the law to help them decide the case properly. So some cases like this, you might find a handful of amicus briefs, maybe in the 5 to 7 brief range. Sometimes in abortion cases, some of these other big high-profile cases, you will have perhaps several dozen groups file amicus briefs. But the basic idea is that an amicus brief will bring in maybe a different angle on the case that the other parties aren't discussing, and it will help the court to decide the case properly.
All right. And then how did this case come across your radar? Like, what is it? Does one of the parties, ask for help, or how does it get on your radar?
Usually, Cato's amicus brief program has been growing over the years, so we, on a regular basis, get requests from people who want Cato to weigh in on their side. In this particular case, I think I've been doing a lot of work on plea bargaining, and the initial request came in saying, there's a plea bargaining issue. Why don't you take a look at this case? And then I read the lower court opinion, and that's where the jury nullification issue leapt off the pages at me when the appellate court was discussing jury nullification, and they kind of had, actually, as you know, when appellate courts discuss jury nullification, sometimes it's in a sneering, disrespectful kind of way. And the appellate court here actually wrote an opinion that says was fair as far as these types of opinions go, as what we've become used to. And they basically said, well, there's a difference of opinion on jury nullification. In our circuit, we don't think we should, send this case back for a new trial just because there's a chance of jury nullification. But anyway, there was that discussion, and that's what leapt off the pages. And I said, this is an important case. This is one where Cato ought to file an amicus brief. We can't respond to all the requests we receive, but on this one, I think it was sufficiently important where we wanted to get a good brief and good discussion of jury nullification before all of the justices on the court.
Mm-hmm. Now, just in summary, what is the crux of Cato's brief, and why did you take the jury nullification angle? I read some of the other briefs, and I noticed some of the other organizations either seem to avoid purposely the jury nullification issue, or even almost sound like apologetic for it. Maybe I'm just reading into it from my expectations, but it seems like Cato was the only one that really took this angle.
Right, and that's one of the reasons why we thought it important to file a brief in this case, because the other parties, as you say, are trying to maybe avoid it. They know that in our current legal culture, jury nullification, people are, as you know, are very ignorant of it or are very hostile to it. And have published, Clay Conrad's book through Cato and the Carolina Academic Press. We've been trying to, enlighten people about the doctrine, that it's perfectly consistent with the original understanding of the Constitution, the original understanding of jury trial. And we thought it especially important for the justices on the court who take the original understanding of the Constitution seriously to consider all of the evidence that we put into our brief and the other works that we cited in our brief. But you're absolutely right. The other parties were either avoiding the issue or were apologetic, and that made it more important for us to get our work into the court and to direct the justices' attention to some of the good works that have been done in defense of jury nullification.
Yeah, I was really excited about it, and honestly, I appreciate it so much because it seems like so many times people are like, well, that's not the winning argument. We don't want to go there. We're kind of at this like balanced spot where you can't talk about it, but you can do it. And so
right.
no one wants to rock that boat. But
yes, and when I give lectures to our interns here, I impress upon them that, your typical law student goes through law school, and to the extent to which jury nullification comes up at all, it's described as a discredited doctrine, something that it's almost like an underhanded trick that defense attorneys use. And so a lot of the people we come into contact with, this has been their legal training. So when they hear arguments from FIJA or from Cato, their initial response is, no, that's incorrect. Our law doesn't recognize that. And so depending on the amount of time you have, we want to patiently explain to those people that what you have been taught is actually not the whole story, and consider the works and the scholarship that we have in our brief. And I think you'll look at this issue a little bit differently.
Mm-hmm. Now, not everyone likes to speculate ahead, but I do note that Justice Sotomayor last year, I think in February, in a talk she did at New York University School of Law, I think, She made some comments actually favorable to jury nullification. And she's also been very notably pro-defendant, I think, in the span of her career, and is also the only justice, if I recall correctly, ever to have presided over a trial by jury of all the Supreme Court justices. So it seems like she could potentially be an ally, and I was wondering what if you share that thought, and if you think there are any other potential allies on the court in terms of the jury nullification argument in particular.
Yes, I agree with what you just said about Justice Sotomayor. I think as I look over the court, I think the two best prospects that we have is Justice Sotomayor, and the other one is on the other side of the ideological spectrum would be Clarence Thomas, who, if you read his opinions, puts a lot of emphasis on the text of the Constitution, the original understanding of the Constitution, and he takes the writings of the framers quite seriously. So I think with the amount of evidence that's in Clay Conrad's book, Jury Nullification, the Evolution of a Doctrine, and some of the other cases and scholarship that we have in our brief, I think those two justices are the most likely to maybe write either a concurring opinion or dissenting opinion, laying out some of the arguments that we have in our brief. The other justices, it's just too hard to say. I don't recall any of the other justices expressing an opinion on jury nullification, either formally in their written opinions or informally, like you had mentioned, like in a lecture or law school type environment where Justice Sotomayor made those comments.
Mm-hmm. I think I looked up when Mr. Gorsuch's confirmation hearing is, and I don't think he's going to get to hear this case. Is that right?
I doubt he's going to be able to sit in on this case, right?
That's too bad, because he seemed like he could potentially also be another ally. It seems like he was selected to sort of be essentially not change the balance of the court, and Scalia was someone who I would have thought also might have been friendly to this argument.
I think that's right. I have watched, I've been in Washington for 25 years. I've seen Justice Scalia in a lot of different settings on the court, in law school audiences and lectures. And he's one of the few that, as you suspected, he also takes the text of the Constitution seriously. He is disdainful of some justices, that emphasize some parts of the Constitution and ignore other parts. He takes pride in defending like free speech provision and also the right to keep and bear arms. And when he has spoken about the jury, I've seen him in audiences stress the point that why the framers thought jury trial was so important was that it was a special institution that stood apart from the government, bringing in citizens, not relying on the professional judiciary or professional prosecutors to decide whether somebody's going to lose their liberty. The jury is a special institution, like a citizen check on the government. And so you're right, he definitely would have appreciated this. And since Judge Gorsuch was very much a fan of Scalia, they viewed themselves as approaching constitutional law in the same kind of way. He was definitely another possible prospect for being good on this issue. But I have to say, I don't want to get people's hopes up. We are definitely looking at an uphill fight in this case because the other judges, as I said, they have been trained to think that jury nullification is improper, and they also tend to, there's a prosecutorial bent on the court. The most prominent person is Justice Alito. He's a very pro-government, pro-prosecution. So we'll have to see what the ultimate outcome of the case is, but it's going to be a tough fight.
So it could end up being decided that the appellate court was right and upholds their decision. It could go for the what do you call the person who's bringing the case to the Supreme Court? I don't have that vocabulary.
There's probably the petitioner.
But the petitioner, thank you. It could go for the petitioner based on jury nullification or not based on jury nullification. Do you think any of the other arguments would be a little friendlier to some of these other justices who would be anti-jury nullification?
It's really hard to say. And I have to remind your audience also that jury nullification, it's not really front and center in this case. It's kind of a little bit of over on the side. The justices are going to be, from their perspective, the main issue that they're to decide is like when somebody has already pled guilty to a case, in what circumstances are they going to grant new trials when that person regrets the guilty plea and they want a new trial? And so they're kind of sitting up above, these trial courts and appellate courts, and they're like, all right, we know we have to grant these in some instances, but we don't want to have everybody who regrets the guilty plea to get a new trial. That would upset the system too well. So they're trying to find that standard by which we're going to grant new trials. And what, again, makes this case interesting is everybody agrees that Mr. Lee was given lousy legal advice, but they're also, their next question is like, but would it have made any difference in his case? And they kind of like, well, seems to be a lot of incriminating evidence in Mr. Lee's case, so it wouldn't make a difference anyway. That's what the justices are going to be wrestling with, whether they're going to say, look, it doesn't matter. The amount of evidence doesn't matter. He had a right to good legal advice, and he had a right to a jury trial. We want the court to come down, with those types of sentiments and statements in their opinion.
Yeah, for all the talk from anti-jury nullification circles of how the judge is there to judge the law and the jury is the fact finder, it kind of almost sounds like they're starting to usurp the fact-finding mission too by saying, well, the facts were clear, the jury doesn't need to hear that.
Right. And we put a couple of examples in our brief about, real cases of injustice to kind of impress upon the court what the implications would be if they don't rule in favor of Mr. Lee. To give you a quick example, we had a guy who got into an argument with his wife. His wife took out a gun and put it to his head. He took the gun away from her and then walked the gun over to the local police station to give it up because he was a felon. A felon who was out of prison, but it was illegal for him to possess a gun. So he immediately walked over to give the gun over to the police department. And as it turns out, they turned around and prosecuted him for being felon in possession of a gun. And, this is the type of miscarriage of justice that happens at the lower court level. And so we want the justices to realize it's not just Mr. Lee's case. They have to think more broadly about how this affects other cases and defendants as well.
Now, where does this case go from here? What's next on its schedule, and what all happens to get us to a conclusion?
Right. The briefing has been going on, and that has concluded now. So all of the briefs have been filed at the Supreme Court. Next is they're going to hear oral arguments on March 28th. So there'll be 1 hour of arguments where they'll hear from both sides. And that's our next kind of like sneak preview to see what the types of questions the justices are asking the attorneys. It'll be like a sneak preview as to what they're thinking about the case. And then after the oral argument is done, then there will probably be at least 6 weeks as the judges behind their closed doors take a vote, and then they'll start writing their opinions. So it'll be probably 6 weeks, and then we can expect a ruling to come down.
All right. Well, good luck to you. We are certainly cheering you on, and I look forward to getting this video edited up really quick and posted today, because I hope that everyone, gets wind of this and learns something from it, no matter which way the case actually goes. But all fingers crossed.
Right. Keep them crossed.
It would be a huge accomplishment if there was some sort of pro-jury nullification something that came out of this. So hopefully, and even if there isn't, it'll be great to know where the court's justices all kind of fall on that. So. Right.
There might be just a brief mention by one of the justices, and so long as that's like a respectful reference to jury nullification with perhaps some citations to some of the works that we've cited, that would be a small victory for us.
Absolutely. And just one last quick question that has just come to me. I was asked a couple summers ago, what kinds of jury nullification related cases I would imagine going to the Supreme Court. And the angle I kind of expected was that someone would appeal based on some of the instructions that have been given. The instructions used to tell jurors pretty standardly, if you believe that this case has not been proved beyond a reasonable doubt, you must acquit. But that if it has been proved beyond a reasonable doubt, you should convict. And that must-should dichotomy was supposed to be what clued them in to jury nullification without actually, educating them about it, just gave them the option if they could figure it out themselves. But more and more, we've been seeing the instructions say you must or will convict. We've seen situations where the jury was asking about jury nullification and they were told it's not a valid option. And I mean, just really strong language, pretty much stamping that out in their minds. And so that was something that I could see potentially going to the Supreme Court. Are there any other types of cases that come to mind that you think that maybe the circuits are divided on, or that's an up and coming way that this is being dealt with that needs to be addressed by the Supreme Court?
Well, I think these instructions that you're talking about that we see from time to time, where it's almost a judge, way out of bounds, really like abandoning his role and basically coming close to telling the jury to come back with a guilty verdict. It's these kinds of like overreaching. That is probably the most likely case that everybody would agree that has gone too far, and that is a good prospect for Supreme Court review. So I think you're right about that. The other areas I think are where we're likely to get some small victories, though, I think is probably more likely in the state courts, where we can get some more state Supreme Courts correcting what their district judges have done in trials. And I think we'll probably start to see some victories there before we get a very good victory at the Supreme Court. Again, with this Lee case, I'd be happy with one justice writing something that's either just very respectful of the jury nullification doctrine. If we just got that much, that would be a victory.
I think we're
I think we're a little ways off from like having the entire court, strongly come down. And that's a little ways off, but that's ultimately what you and I are both aiming for.
Yes. Well, thank you so much, Tim. I definitely appreciate your time and your expertise filling me and all of our audience in on this. Tim Lynch, Director of Cato's Project on Criminal Justice. Hopefully all goes well in the coming weeks, and I'll be checking in with you to congratulate you soon. Thank you, Tim.
Thank you. Thank you for having me.
Thank you again to my guest, Tim Lynch, and the Cato Institute, a public policy research organization dedicated to the principles of individual liberty, limited government, and peace. I'm Kirsten Tynan, Director of the Fully Informed Jury Association. We are a nonprofit, nonpartisan educational organization dedicated to preserving the full function of the jury by fully informing everyone of jurors' rights and responsibilities, including the right of conscientious acquittal by jury nullification.